There are a number of important steps in a trial. We'll outline what happens at each step. The arraignment.
Yes, Ms. Fitzpatrick?
Your Honour, I present an indictment charging Kevin Morrison with 1 count of assault, occasioning bodily harm, and I ask that he be arraigned on that indictment.
Arraign the accused.
Kevin Morrison, you are charged that on the 25th day of January 2010, at Mackay in the state of Queensland, you assaulted Stephen Talbot and thereby did him bodily harm. How do you plead? Guilty or not guilty?
Not guilty.
The indictment is the formal document which contains the charges brought against the defendant. If the plea is guilty, or if the prosecution withdraws the charge, the jury won't be needed.
Inform the defendant of his right to challenge jurors and impanel the jury.
Kevin Morrison, these representatives of the community, whom you will now hear called, may become the jurors who are to decide between the Crown and you on your trial. If you wish to challenge them, or any of them, you or your representatives must do so before the bailiff begins to recite the words of the oath or affirmation.
Forming the jury.
Ladies and gentlemen of the panel, please answer to your name.
The names and numbers of all jurors are placed in a barrel and drawn one at a time by the judge's associate.
Number J 306, Stephen Carter.
Present.
As you are called, walk forward to take the juror's oath or affirmation.
You will conscientiously try the charges and decide them according to the evidence. You will not disclose anything about the jury's deliberations other than as allowed or required by law. So help you God.
So help me God.
Number J 334, Kate Roberts.
Yeah. I'd like to make an affirmation.
Do you solemnly, sincerely and truly affirm and declare that you will conscientiously try the charges against the defendant and you will decide them according to the evidence? You will also not disclose anything about the jury's deliberation other than as allowed or required by law?
I do.
Even if your name is called, you may not become part of the jury.
Number J 326, John Maloney.
Here.
Both the prosecution and the defence have the right to challenge a prospective juror whose name has been called without giving any reason for the challenge.
Challenge.
If you are challenged, you shouldn't take it personally. There's no reason to feel embarrassed or offended. The prosecution and the defence are simply exercising their legal right to have a say in selecting the jury.
Number J 313, Margaret Lindsay.
Here.
Stand by.
Before a trial commences, the prosecutor will tell you the names of witnesses, potential witnesses, or people involved in the case. This allows prospective jurors to advise the judge if they know anyone associated with the trial, or if they feel for some other reason that they could not act impartially.
Those are the witnesses for the prosecution.
Members of the jury. In all criminal trials, it is essential that every member of the jury be, and be seen to be by all fair-minded people, to be completely impartial as between the prosecution and the defendant. Sometimes a juror knows a prosecution witness or something about him or her, or knows the defendant or something about him or her, or knows a relative or an associate of some such person. And on that account, the juror may feel that he or she cannot be seen to be completely impartial. If, for any reason whatsoever, any one of you feels that you cannot be, and by all fair-minded people be seen to be completely impartial in this case? Please raise your hand now. Would you like to come over here and tell me what the problem is?
At this point, the judge will excuse any jurors whose impartiality could be called into question.
Thank you. Juror number 5 is excused. Those of you not impanelled on this jury may be required for selection on another jury today. Please follow any instructions given to you by the court officers. You are free to leave the courtroom now.
If you are not selected for a jury today, you will still need to check the law list in the newspaper or on the court's website each day, or call the telephone number on your summons to find out whether you are required to attend. The trial.
Members of the jury, Kevin Morrison is charged that on the 25th day of January 2010 at Mackay in the state of Queensland, he assaulted Stephen Talbot and thereby did him bodily harm. To this charge, he says he is not guilty. You are the jurors appointed according to law to say whether he is guilty or not guilty. It is your duty, therefore, to pay attention to the evidence and say whether he is guilty or not guilty of this charge. Members of the jury, as early as convenient, you must choose a person to speak on your behalf. You may change the speaker during the trial, and any one of you is free to speak.
This person is known as the jury speaker. Often during the trial, matters of law arise. These are for the judge to decide and are usually argued in the absence of the jury, which means that you will be asked to leave the courtroom.
I have some matters of law before my learned friend opens her case.
How long will they take?
About half an hour.
This sort of legal argument can go on for much longer than anticipated, so please be patient.
While you are responsible for the verdict in this case, I am responsible for any questions of law that may arise during the trial. As I have to do some work with the barristers that doesn't involve you, I will allow you to go to the jury room and have your morning break now.
During the trial, you must never discuss the case with anyone other than your fellow jurors. That means not with family, friends, strangers, or the bailiff. Otherwise, the trial may have to be abandoned and the jury discharged. There are instances where trials have had to be abandoned or retrials ordered because jurors made their own investigations into the case. Such investigations can lead to unfairness because information in the public arena is not always accurate, and neither the prosecution nor the defence will have the opportunity to test the material. Except in certain limited situations, it is an offence to publish to the public information about a jury's deliberations or information which may identify a juror. The court takes your privacy and safety seriously. Your personal details will never be publicly released. If you have any concerns, talk to the bailiff. During the trial, you are usually free to go home at the end of the day's proceedings. Don't be influenced by media reports about the case. It is your job to be open-minded and assess the case with your fellow jurors on the evidence you see and hear in court. This is important because it is about the fairness of our criminal justice system. Prosecution case. When the trial commences, the prosecution will outline the case against the defendant. The prosecution will summarise for the jury the evidence expected to be given in the prosecution case.
Ladies and gentlemen of the jury, today you will hear from Stephen Talbot, who was assaulted by Kevin Morrison and received injuries so serious that...
Defence evidence. There is no obligation for a defendant to give or to call evidence. The prosecution must always prove its case beyond reasonable doubt. But a defendant may give or call evidence if he or she wants to. If that happens, then the procedures followed by the prosecution will apply to the defence. Evidence of witnesses. Witnesses are usually called into court and give their evidence from the witness box. They will take an oath or an affirmation to tell the truth. They will then be asked questions by the party who called them. The evidence of witnesses can be tested by cross-examination. As a juror, you will need to watch and listen carefully as witnesses give their evidence. Matters which will concern you are the truthfulness of the witnesses and the reliability of their evidence. Addresses by barristers. After all of the evidence has been presented, the prosecution and defence will address you. That is, each will make arguments in support of their own case.